This case considered the issue of Mariva orders, and whether or not an order for a defendant to pay an amount of money into court as security went beyond the limits of the purpose of a Mariva injunction after the defendant had tried to divest himself of his assets before the outcome of an action against him under the Trade Practices Act. In this case, a company purchased 2 taverns from a man, but later brought an action against the man for breaches of the Trade Practices Act, on the basis that the earnings from the taverns had been misrepresented. The man proceeded to divest himself of his assets, and when the company discovered this, they were successful in obtaining a court order for the man to pay into court an amount of money as security if a judgment was made against him. The man appealed against the making of this order on the basis that there was no statutory power in Australia to grant a Mariva injunction, and that it had required him to pay into court money which was not in his possession. He argued that the order was also not in accordance with the requirements of a Mariva injunction because it required him to pay into court an amount of money as security. The company, however, argued that the court did have the power to grant such an order to preserve the man's assets, and that the man had stripped himself of his assets to prevent paying a damages claim, and the order to restore these funds was appropriate. The central issue for the court was whether the court had the power to make the order for security in the circumstances. The court ultimately held that the order was